Welcome to this session. I am Concilia Were, and I will be taking you through trademarks, industrial designs, which fall under the category of intellectual property known as industrial property. I will consider the definition of trademarks, what can be registered as trademarks and what cannot be registered as trademarks. And I will also give you some examples of trademarks. I will also consider the definition of industrial designs and indicate to you what can be registered as industrial designs and what cannot be registered, and also a few examples on industrial designs. A trademark is a distinctive sign that is used by a trader to identify its goods or services and to be able to distinguish those goods from those produced or provided by others. And to know what a trademark covers, there are several aspects. There could be a distinctive word, it could be a letter, it could be a slogan, it could be a device, a brand name, a heading, a label, a ticket, a signature, color, numerals or combinations thereof. And this could be in two-dimensional or three-dimensional forms. There are some jurisdictions that protect audible signs, or rather we call them sounds, or olfactory signs, that is the smells, holograms, scents, or even motion signs. For example, the sound that comes out of a Nokia phone or an iPhone, that sound can be protected as a sound mark. For you to protect your mark, it has to be distinctive, and the distinctiveness has to be in relation to goods or services. So this means that if you want, for example, to protect a mark, it has to relate to specific goods or specific services. For example, Apple has registered its trademark, which is a very distinctive mark for mobile phones. So nobody relates that an apple, which is just a fruit, could relate to mobile phones. And that's why we are talking about the aspect of distinctiveness. It should not be something that describes the specific goods or services that you want to protect. And then what can be registered? You can register the name of a company, an individual or firm, which should be represented in a special or a particular manner. You can also register the signature of an applicant for registration. You can have an invented word or invented words. Some people do combine initials of family members and come up with an invented word or a coined word. Or you can have a word or words having no direct reference to the character or the quality of the goods. That means that if it is, for example, a trademark used for packaging water, then it should not be directly referring to the water that you are packaging. It needs to be having no direct reference to the character or the quality of goods, and also not being according to its ordinary signification, a geographical name or a surname. There are several creatives that have protected their trademarks, like this trademark is a trademark. The first trademark is a trademark that is protected by one creative known as Aziad. And the second one is a trademark that is protected by Bahati. It was used in a reality show. And there's also this trademark registered by some creatives. They were Jesus family, and they are using it for the purposes of entertainment. And this shows that it is very important for you to register your trademark before you can use it. There is also another one, the famous one, the Anguka Nayo trademark, which has been used in music, and it has become very famous in Kenya. And that's why we are saying that you need to protect your trademark for you to be able to use it in your trade. So just I've said that there are aspects to consider when registering trademarks. We also have to note that not everything is registrable as a trademark. And I've said that for a mark to qualify as a trademark, then it has to be distinctive. So what that means is that whatever lacks distinctiveness then would not qualify as a trademark. Then any mark that is likely to deceive or cause confusion is also not protectable or registered as a trademark. And also identical or resembling trademarks, like for example, when you want to register a mark that has some pronunciation that will be similar to another mark, then that means that that mark will be having there'll be that intention to deceive the consumers, that trademark comes from a certain institution when it actually comes from another one. So if they are identical or resembling trademarks, then they will not be protected. And I've also talked about descriptive words. For example, if you want to register a mark for water and you're calling it Maji, that basically describes the water and therefore will not be protected as a trademark. Then the law also says that anything that is entitled to protection in a court of justice or will be contrary to law or morality or is a scandalous design would also not be protected as a trademark. In terms of the creative industry, if you have, for example, a fashion brand name, that fashion brand name can be protected as a trademark. Similarly, if you're in the music industry and you have a music label, logo, or name that you're using for purposes of marketing your music, then you can also protect that as a trademark. If you are engaging in podcasts and you're using a certain logo or name for your podcast, then that podcast name can also be protected as a trademark. In the area of film production, for example, if you're having a specific logo or name that you're using in the film production, that specific logo or name can also be protected as a trademark. Or if you have a company logo, that can also qualify as a trademark. For the artists who use names that are not their real names, such names could actually be also protected as trademarks. Those, we call them the stage names. They can actually be protected as trademarks. Similarly, for those creatives in the cosmetic industry, they can also protect their various cosmetic brands as trademarks. And this is just an example of some trademarks. And to explain what is the purpose of a trademark, that it is to be used to distinguish the goods of one undertaking, the goods or services of one undertaking from another undertaking. That's why you see that we have a similar product, but there are different identifiers or logos or names that are used on that product so that they are able to distinguish the goods of one undertaking from another. And with the time, you find that because of that use of these specific trademarks and the reputation that is built by these specific brands, you find that consumers would buy specific products or services because of those specific identifiers. For you to protect your trademark, you have to, first of all, identify which specific class the trademark falls in, because trademarks are usually registered in respect to specific classes based on the International Classification of Goods and Services, which is usually known as the NIS classification. There are actually 45 classes, and from class 1 to 34 covers goods, and class 35 to 45 usually covers services. And then to note that you have to keep checking the right edition and version that is being used by KIPI so that you can be able to select the right goods or services. And this is because the versions keep changing and the editions also keep changing. And by the time you're filing your application, you may find that the edition has actually changed or the version has changed. And that means that your goods might have moved to another class. So it is important for you to keep checking the specific edition or the specific version. Registration in a specific class is very important when it comes to enforcement of your rights. This means that if you have registered your trademark in class 9, you can only enforce it in class 9. And that means that if somebody else registers a similar or identical trademark in another class, then you will have no standing to go and ask why they're using that specific trademark in that specific class. So if you want to use your trademark in several classes, then you need to identify that specific class that you want to use and then register all those classes so that you can be able to enforce your rights. For example, a musician registering their artist name may want to register that in class 41 for entertainment services, and they could also register in class 9 for sound recordings. So this means that a single registration in one class does not protect the name in another class. Again, to emphasize that if you want to use your trademark in different classes, then you need to register in those specific classes that you want to use that trademark. So one may ask, is a trademark protected forever? Registration of a trademark is usually for a period of 10 years from the registration date. And this means that once the 10 years lapse, that trademark is not protected. But you can renew that trademark after every 10 years indefinitely, meaning that even when you are dead, you can still allow your family members to be able to use that trademark, so long as they keep renewing. And of course, during death, then there is the aspect of transmission of that trademark to the right persons who will be able to use that trademark indefinitely. In terms of the registration process, first of all, when you have a distinctive sign or a distinctive mark, first of all, you need to conduct a search. The search is not mandatory, but it is very important for you to be able to know which are the existing rights that are there, so that you do not have to waste time using a trademark that has already been protected by another person. Once you get results about the search, if the results allow you to proceed with the registration, then you file an application for registration of a trademark. Once you file that application will be examined by the KIPI examiners to determine whether your trademark actually falls or complies with the Kenyan laws. Then afterwards, that trademark will be advertised for a period of 60 days. The purpose of advertisement is to give the public an opportunity to raise any objections or oppositions in case they feel that that mark should not be protected in the Kenyan territory. If there is no opposition or objection to the registration of that mark, then you will be issued with a certificate of registration. And that means that you gain exclusive rights and you can be able to enforce any infringement that may accrue from the use of your mark. There is also an opportunity to carry out post-registration actions, for example, changes of name, change of address, assignment, or licensing. Again, this you need to look at the KIPI website to get more information on that. The practical tips that I would give is that, first of all, you need to carry out a search before you use a mark, that is the word or the logo, so that you do not infringe on existing rights, and also to know whether whatever you want to register is actually a distinctive mark as per the Kenyan laws. Once you get that certification that the search allows you to register that trademark, then you need to proceed and register your trademark. And after registration and you have the certificate, you need to use that mark consistently so that your mark is not removed from the register on the grounds of non-use. Next, I'll move on to industrial designs, and I'll show you a few examples of industrial designs. And one thing to note is that the textile industry has a lot of industrial designs that need to be protected. We take the industrial designs in the textile industry for granted, but this is an area that really needs to be looked at. And it's not only the textile, but also the designs that are generated from the textiles. For example, and this is from Ghana. Ghana has protected a lot of their kente designs, though currently they are protected as a geographical indication. But again, just to show you that various patterns on textiles can actually be protected as industrial designs, and therefore the textile industry needs to really be looked at when it comes to issues on industrial designs. You find that in the perfume industry, most of the perfumes have very unique designs, that is the bottle designs. These designs need to be protected. And when you're talking about industrial designs, we do not look at the functionality of those designs, but just the outward appearance. The aesthetic features are what we consider when you're looking at industrial designs. Most of the times, consumers will make purchases because of the beautiful design of, for example, a bottle or a clothing or whichever product that they want to purchase. So design is very important when it comes to marketing and also when it comes to branding, and it helps in terms of ensuring that the products that the consumers purchase actually look beautiful and they have some value. When it comes to handbags, you find that we have different kinds of handbags, and these also fall under industrial designs. The various patterns that you see on those handbags are actually categorized under industrial designs. Similarly, when, for example, you're going to purchase water, you'll find that there are different bottles that are used in bottling the water, and most times you'll be able to you'll buy the water because of the aesthetic aspect that comes with that bottle, not because maybe the water is tasty or something of the sort. So when you're looking at industrial designs, we're just looking at the overall appearance of a product, resulting from one or more visual features of the shape. There's a configuration, there's a pattern, ornamentation of that product. Industrial designs are concerned with the eye appeal, that is the outward appearance of a product, and not the functionality of that product. And I've talked about the aspect of the shape, the configuration, the pattern, or the ornaments. For you to register an industrial design, that design has to be new and it should not have been disclosed to the public anywhere. So in terms of the criteria, we use what we call universal novelty. It has to be a global novelty, meaning that it has not been disclosed anywhere, not only in Kenya, but globally. And that means that whatever you come up with as a design has to be something that is novel. Then the duration for protection of industrial designs is usually 5 years, renewable up to a maximum of 15 years. And that is from the date of filing your application. So once you file the application, you'll get protection for 5 years, and then you can renew for another 5 years. And once the 5 years lapse, you renew again for another 5 years. And the maximum is 15 years. Beyond that, it means that that industrial design falls within the public domain and anybody will be able to use it for any purpose they want to use it. To register your industrial design in Kenya, first of all, you may want to conduct a search. The search is not mandatory. This means that you can skip the search process and go directly to the application. So once you file the application, the KP examiners will conduct a formality examination. And if the formality examination is positive, which allows you to move to the next stage, a substantive examination will be done. And once the substantive examination is done and there's an approval that the design can be registered, then that design will be published in the Industrial Property Journal for a period of 60 days. And again, the reason for publication is to allow members of the public who have objections to registration of that design to raise any objections. But if there is no objection after the 60 days advertisement period, then it means that your design will be registered and you'll be issued with a certificate of registration of industrial design. Just to give a few examples of industrial designs, I had shown the kente, which basically shows the various fashion patterns that can be protected as industrial design. Also, in the jewelry space, you find that there are people who have very unique or new jewels that can be protected as industrial designs. Similarly, in the furniture space, you find that there are different kinds of furniture that can be protected as industrial designs. Also, in the shoes industry, various kinds of shoes can be protected as industrial designs. And also in the product packaging, for example, using the example of the water bottles, they can also be protected as industrial designs. It is important to note that an industrial design is not registrable if it is protected under the Copyright Act. So in this case, you'll have to choose whether to protect your design under the Copyright Act or you protect it under the Industrial Property Act. So you have to take note of these limitations before deciding on under which regime you're going to protect your industrial design or your copyright works. A key aspect to consider is that you need to protect, and by protection I mean you need to register your trademark or your industrial design before using. Registration is very important because it will help you to enforce your rights against any infringers. Thank you.